The state of Illinois responding to a federal judge saying that the gun and magazine ban is unconstitutional with a filing in the appeals court. Got the latest there, but we also have the latest debate about safe gun storage, a proposed law moving through the State House. Is that going to pass before the end of the month? We'll be watching closely. It's Illinois in Focus Daily. I'm Greg Bishop. Thanks for waking up with me each and every weekday morning. The live show goes on at about 8 o'clock. So if you want to join the live chat, you can do that. Or if you can't make it to the live show, don't worry. You can listen to it in its entirety either back here on YouTube with the Center Square, or you can find the podcast. If you're traveling around, going on a road trip this weekend, get the show that way. And also don't forget about the weekend edition as well. I'm going to be joining the Center Square's reporter Jim Talamonte out of Chicago to talk about a whole host of things. So that'll be coming out. But clearly here on YouTube, you can get news clips and segments of the show and more. So make it happen. So we've been tracking the lawsuit against the state's gun and magazine ban since before it passed January of 2023 and was enacted, because there's just a lot of interest here in the state of Illinois. There's more than, 2.2 million FOID card holders in the state, in a state that's less than 13 million. So there's a significant amount of gun owners out there who have complied with the state law to get a firearm owner ID card. Illinois is one of 4 states that require something similar to that. That's being challenged in federal court, but I'll have to get updated on where that's at. It's been challenged in state court as well. Several times it's been deemed unconstitutional by county level judges, but those cases don't really proceed too far. But the gun ban, the challenge there went all the way up to the U.S. Supreme Court on preliminary grounds in 2023. And on preliminary grounds, the Supreme Court said this case isn't ready yet. So the Supreme Court does have a case from Maryland, Schnope, but they haven't really acted on that. They haven't decided whether or not they're going to take that case. When they rejected Illinois' case on preliminary grounds, they said this case isn't ready. It's not ripe yet. They gave it back to the appeals court, which then kicked it back to the district court. And then in the summer of 2024, you had Judge Stephen McGlynn hold a 4-day bench trial. Tons of information and background on that. Everything about what the appeals court said on preliminary grounds, that semi-automatic firearms are too similar to military firearms. Well, back at the district courts, they had a 4-day hearing talking about the differences between military grade and civilian grade, everything from the metallurgy to the various components and how they're manufactured and tested and such. So interesting stuff there. But Judge Stephen McGlynn in the Southern District ultimately ruled against the state, saying that the law was unconstitutional. But he put a stay on his order, and that stay being re-upped by the appeals court, and the appeals court sat on it for like 4 or 5 months before they were asked by the plaintiffs to give a briefing schedule because they're in limbo right now. And the court immediately turned around and said, here's a briefing schedule, plop. And yesterday was the deadline for the state to reply to the district court. Let's take a look at that really quick. Here is the case, and you can find this at thecentersquare.com. 267 pages of it. All right, 267 pages. How about we do this? How about we just go to what the state has as summary of the argument. All right, let's do that. Summary of the argument. So we'll go down to page 17 here. Scroll. You can see all the different sections that they've got going on. Where are we at? We're only on page 2. Holy cow. All right. We'll get there. So the state filing this yesterday. The plaintiffs file tomorrow, and they will ultimately, or not tomorrow, next month. I'm sorry. That typically it's 30 days in between filings. So the state will file yesterday. The plaintiffs will file next month, and then the state will have a chance the month after to reply, and then we can anticipate getting some kind of oral arguments set up in the appeals court on this case. But let's go to the summary argument from the state yesterday in their filing. They say in Beavis, which was on preliminary grounds, the Beavis case out of Naperville, challenging Naperville's gun ban, and then challenging the state's gun ban. So in Beavis, again, on preliminary grounds, because that case is still back in the district court on the merits. And actually, that hearing has been held off while this case proceeds. Anyways, in Beavis, this court determined that plaintiffs were unlikely to succeed in the merits of their Second Amendment claim because, based on the record before it, The Act's restrictions satisfied the text and tradition test outlined by the Supreme Court in Heller, Bruin, and subsequently reaffirming in United States v. Rahimi. On remand, state defendants developed substantial additional evidence that confirms the preliminary determination in Bevis, as well as the similar conclusions reached by every other court of appeals to consider the issue. And lists all the different cases. The district court's contrary determination was incorrect, they say, as a matter of law for several reasons. First, the act does not restrict conduct within the scope of the Second Amendment's text because the items it regulates are not arms, the state argues. The evidence showed that the regulated items are offensive, militaristic instruments that are not commonly used for individual self-defense, which is the core lawful purpose protected by the Second Amendment. In addition, large capacity magazines, LCMs, assault weapon attachments, 50 caliber cartridges, and accessories used to increase the rate of fire of semi-automatic weapons are not arms because they are accoutrements that are unnecessary to operate firearms. Accoutrements are essentially like attachments. I think that's ultimately what that word means. When a soldier was putting on different types of armor, those were considered accoutrements. Second, the act is consistent with the principles that underpin our country's regulatory tradition. States' defendants' evidence establishes a long-standing tradition since the founding of restricting civilian access to especially dangerous weapons and reserving them to use to train military and law enforcement professionals. Moreover, the more nuanced approach to Bruin's second step is warranted because the act was passed in response to unprecedented societal concerns brought by the dramatic technological changes in weapons technology, the increasing frequency of deadly mass shootings that are committed by lone shooters armed with assault weapons and LCMs. And under this approach, the Act's restrictions are consistent with historical tradition of regulating especially dangerous weapons, including the minimal burden that those restrictions impose on the rights to self-defense and the justifications for imposing that burden. Finally, the endorsement affidavit requirement, where you have to register your firearms, is constitutional, the state says, as this court has already unanimously determined, the appeals court in this case, in Bevis, because the requirement's no cost, simple process, and automatic conferral of rights do not necessarily prevent law-abiding responsible citizens from exercising their Second Amendment rights. So that's the summary of the argument from the states that they filed yesterday. Again, the plaintiffs file next month, and then the state will file again the month after that. Then sometime this summer we could possibly see a hearing. And could that have a determination before the end of the season, before the end of the year? Whatever happens there, likely it's going to go to the U.S. Supreme Court. And if the U.S. Supreme Court gets it, and they haven't acted on the Snope case yet out of Maryland, could Illinois' case be the case that the U.S. Supreme Court takes up? Especially with that pretty thick record that the district court generated from a 4-day bench trial. So we'll be watching that closely. But while that's all going on, while the state's having to defend its gun ban in federal court after a district judge said it was unconstitutional, you've got the state looking at more gun laws, including Senate Bill 8, which was brought up in the House Gun Violence Prevention Committee with a subject matter hearing yesterday, and it's already passed the Senate. Senate Bill 8 already passed the Senate last month. Now it's in the House, and here's State Representative Maura Hirschauer talking about the measure. She says, will bring about public safety by requiring people to lock their firearms up under certain circumstances. Here's Representative Hirschauer.
Storage can reduce unintentional injuries, suicides, and intentional harm, like school shootings. About 75% of guns used in school shootings are accessed at home.
So she's saying that we need to lock firearms up so kids don't take the firearms and shoot up schools. But you've got the likes of Josh Witowski from Illinois Federation for Outdoor Resources. He said that this thing has already, this idea of making firearms inoperable has already been found unconstitutional by the U.S. Supreme Court.
Removing the ability to place in some other location where a reasonable person would be believed to be secure from minor under the age of 14. That means you are required to leave the firearm inoperable, either by locking it up in a box or by having a trigger lock on it. This has already been determined to be unconstitutional by the United States Supreme Court in D.C. v. Heller. Specifically, they state, We must also address the district's requirement as applied that firearms in the home be rendered and kept inoperable at all times. This makes it impossible for citizens to use them for the core lawful purpose of self-defense.
So Wojtowski talking about Supreme Court precedent that you can't say you have to have your firearm inoperable, because then it takes away an individual's ability to lawfully use a firearm in self-defense. Because what's the saying some in the Second Amendment community have? When police are minutes away, what is, somebody may know that in the chat. When seconds matter, that's what it is. When seconds matter, police are minutes away. Right? You get that? And also, I mean, another saying, I'd rather be judged by 12 than carried by 6. Interesting stuff there. Anyways. All right. So, Wojtowski talking about how, that's already been found unconstitutional. We'll see how that argument stands. But there's two components to Senate Bill 8, not just the safe gun storage aspect, but you've also got the shortening of the time frame to report lost and stolen firearms, and including civil penalties if you don't report lost and stolen firearms within that timeline prescribed by what could be state law.
The reporting measures that we have in this bill will give law enforcement the tools they need to crack down on lost and stolen guns and hopefully end that cycle of violence.
So they want to be able to have police getting those lost and stolen reporting requirements in place, and there could be civil penalties. Freedom's Steel, Todd Vandermeide, former NRA lobbyist and gun rights guru, as he says, gun rights advocate. He talked yesterday remotely in front of the committee about how the lost and stolen provisions and tacking on a civil penalty if you don't follow the law, well, that could lead to some severe consequences, like the loss of a firearm owner ID card and ultimately confiscation of your firearms.
The addition of being able to revoke a FOID card for failure to report a property crime. And even under the second iteration of this, the penalty is only a Class A misdemeanor. The only other Class A misdemeanor that we do anything about is the domestic violence crime, which is a crime of violence. However, now you're talking about revoking FOID cards for mere failure to report a property crime. This sets a new low, and I think it runs afoul of all the Supreme Court precedent that we've had.
So Vandermeide making those points and staying in the debate, going back and forth with people on these issues. And here's some more of yesterday's hearing.
Okay, I just have one question.
Yes, ma'am.
What is a trap shooter?
Clay pigeons. Are you familiar with clay pigeons at all? Mm-hmm. So it's a sport. In fact, it's a sport that brings in a lot of tourism to the state of Illinois. We have an entire complex in southern Illinois dedicated to it. In fact, there's a bill that's agreed upon that's going to allow 14-year-olds to work at that complex as scorers. But it's clay pigeons as they go through the air, and you shoot a shotgun to shatter the pigeon.
So again, the question was, what's a trap shooter? Because Wojtowski was talking about trap shooters are younger in age sometimes that are competing, trying to get scholarships, and some of this law could impact their ability to do such things because they, parents would have to lock up their firearms if 14-year-olds around. And the question, kind of highlights a lack of knowledge about the firearms space. When a legislator asks what's a trap shooter, and they're going to be able to vote on this legislation. More back and forth from some of the Second Amendment advocates and those who were pushing for this law to be put into place. Again, Vandermeide going back and forth with one of the proponents from GPAC about how this could impact people coming in from other states.
I can tell you, I happen to be the president of the largest gun club in the state of Illinois. We have almost 3,000 members. We host a lot of matches, and evidently the proponents don't understand how some of these matches work, because our 3-gun competition, pretty much every individual that shows up to compete has at least 3 firearms, a handgun, a shotgun, and a rifle, if not a backup firearm, that would run afoul of PICA. And I can tell you right now, we are already seeing a decline in our out-of-state participation for regional and statewide championship matches. And regardless of how you want to focus on FOPA or whether or not this applies in A and not B, I can tell you what the interpretation for the people who surround us, who like to come to our club to compete in recognized matches, is going to be they're not going to come. We've already seen a 30% drop off since the beginning of PICA with our three-gun competitions.
Yeah,
And that's the way it's going to be treated. And I'll tell you what happens, if you get pulled over in Cook County, they're going to say, tell it to the judge. We'll let him sort it out. In the meantime, your firearms are confiscated. You're charged with whatever they can drum up at any given moment. And that's how it's going to be applied.
I don't think this provision would apply to that situation. It's limited to firearm prohibited by 24-1.9.
Yes, and all our competitions are done with AR-15s, AK-47s, semi-auto shotguns that have more than 6 rounds. Evidently, you've never seen a three-gun match. I would suggest you go to YouTube and look up what three-gun shooters do.
And there was a little bit of an uncomfortable silence there for a span of some time after that exchange. The measure did not advance out of the House Gun Violence Prevention Committee because it was only a subject matter hearing. Today, no, that's tomorrow because I am off tomorrow. Tomorrow's the deadline to get Senate bills out of the House. However, they can waive the rules and add new deadlines to these measures. So this measure may be one of those where they waive the rules and say that the deadline to get it out of committee is, I don't know, May 25th or something. I don't know. I'm just making that up. But they could do that, right? The Democrats have the super majorities and they can just, on a voice vote, waive the rules. So we'll be watching to see what happens with Senate Bill 8 before the end of session, and we'll also be following up on the ongoing litigation in the federal appeals court over the gun and magazine ban. As you can read all of this and more at thecentersquare.com. Get the newsletter. Donate. We're a nonprofit newswire service covering what's happening in state government for you, the taxpayer, to be able to be better informed. And don't forget, you can wake up here each and every weekday morning with The Center Square on YouTube. Programming note, though, I'm off tomorrow, Friday, but we'll be back at it live on Monday. All right. Like it up. Share it up. I'm Greg Bishop. This is Illinois in Focus Daily.